You ready? Good evening, ladies and gentlemen. Welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce the members of town government that act as advisors to this board. To my left is Paul Hennings, counsel to the board. To his left is David Flynn, assistant planning director. To his left is Tom O'Brien, a planner in the planning department. To his left is John Bongino, town building director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals, etc. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of application before the board are area variances. Area variants deal with dimensions such as lot area, frontage, height, setback, and parking spaces. New York State statute mandates that the board must consider the following criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted here for you. Number 1, whether an undesirable change will be produced in the, in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception variances are different than area variances. When we have a special exception application before us, I will explain the different criteria. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward. Submit your affidavits and mailing receipts to Mr. O'Brien. And then you will be sworn in the podium and we will be given the opportunity to explain to this board why you need the variance. After the applicant is done speaking, all interested parties will be given the opportunity, and only one opportunity, to be heard. So please organize your thoughts, keep your remarks factual that are related to the case, and then I will ask the applicant to come to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. We okay? Okay. Paul, can you do me a favor? Just close that door so he doesn't hear the... There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. Number 3, applicants can wait and be notified by mail. Okay. Okay. First case is 16676, Matthew and Tracy Lorelli. Come on up, please. 7 2nd Street, Wisconsin. Location, north side of 2nd Street, east of Shenandoah Boulevard, Wisconsin. Property zone R10. Request variance to increase the maximum height of a fence from 6 feet to 8. Existing 6-foot fence on top of a 2-foot wall. Reduce the distance from any lot line from 6 feet to 3 for an existing pool. Reduce the minimum distance from pool to dwelling from 10 feet to 8. Reduce the minimum side yard setback from 12 feet to 0 and total side yards from 28 feet to 17 for an existing 84-square-foot shed. Increase the maximum paving in the rear yard from 25% to 61%. I think, did he hand in everything to you? You need to hand in all your affidavits and your mailing receipts. Please. Let me have your name and address, please.
Matt Lorelli, 7 2nd Street, Wisconsin, New York.
Okay. Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay. You want to tell us why you're here, please?
For a variance, for a pool and a shed.
And a fence?
Yes, and a fence.
Okay.
Correct. The variance that I'm looking for, the reason why I don't feel it would produce an impact on the adjacent properties, and most of the neighbors have pools. The surrounding homes do have substantial setbacks, at least from my home as well. The parcel is small, but the pool and the shed are kind of proportionate to the lot. Unfortunately, it's already been installed, so I don't really have an alternative at this point. But as far as the environment, it's not a sensitive area, so I don't think it would cause any kind of effect as far as that is. And I mean, the shed is old. It was there. It had to be moved in accordance to where I had put the pool. But like I had said, I don't think there's any, I don't see any other problems as far as any other neighbors or anything at all. That's pretty much it.
Okay. You know, as we look at this, and I say it all the time, even though it's existing, we look at this as if we would approve it if it wasn't existing.
I understand.
Okay? All right. Planning? Gentlemen?
No questions.
Okay. Thank you so much.
Thank you.
All right. Is there anyone here that would like to be heard on this application? Come up, please. All right. You need to state your name and spell your last name.
Fred Noschese, Noschese.
Okay. And your address, Fred?
I live in Merrick right now, at 1808 Grand Avenue in Merrick, but I own the property that is behind the subject's property at 7 First Street.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. You want to tell us?
Okay, here's a question. I really only have a question. Which lots are we talking about that you own? I have a survey that was done in 2006 that sees, I could see on the survey that there's a stockade fence or chain link fence and a stockade fence adjacent to it. I'm just wondering, is it lot 27, 28, and 29? If that's the case, then I don't have an issue. If it's also 26 and 25, then I could see that the fence is about 3 feet or 4 feet taken on my property line. So I might have an issue depending on what lots we're talking about here.
I'm not sure what lot, but this is the white vinyl fence with the retaining wall. Is that the one you're talking about?
I'm looking at a survey. Quite frankly, I'm not sure.
What was the address of the house?
7 First Street.
The survey that he just submitted, the house directly behind his
Yes.
is 6 3rd Street.
Well, I'm looking at my survey here. That's why the question comes up of which lot we're talking about for his property.
Yes.
I'm lots he speaks of are 36 and 38 are what this parcel comprises?
Okay. Did you hear what the gentleman said?
No, I
Mr.
didn't hear
O'Brien?
that.
There are lots 36 through 38.
Ah, okay. So it doesn't affect me at all.
No.
Okay.
Okay?
Very good. No problem.
Thank you so much. Is there anyone here, anyone else? Okay. You don't need to come back. Okay? I'll entertain a motion to close the hearing.
So moved.
Second.
Israeli moved in second. All in favor?
Aye.
Motion carried. Next case is case 16677, El Sadi, El Monteshed. (23) Colonial Drive, Smithtown, location northeast corner of Veterans Memorial Highway and Colonial Drive, Smithtown. Property zone R21. Request variance to reduce the rear yard setback from 75 feet, 30 feet existing, to 8 feet for a 698 square foot deck. Reduce the side yard setback from 16 feet to 10 for an existing 250 square foot deck with hot tub. May I have your name, please?
Al Sayed Al Munshid,
And your address.
23 Colonial Drive, Smithtown.
Okay. Raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
I swear to say the truth, nothing about the truth.
Thank you. Use the microphone if you can.
Okay?
Thank you so much. All right. Will you want to tell us why you're here, please?
I'm here to get the permit for hot tubs and partial part of the deck.
Okay.
The previous owner filed the paperwork and comes back and need a variance, so I apply for the variance.
Okay. Planning? Okay. Gentlemen? Okay. Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Come up, please. Let me have your name, and you're going to need to spell your last name for me.
That's John DeFalco, D-E-F-A-L-C-O,
And your address, John?
17 Colonial Drive.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. I'm his adjoining neighbor to the north. I see no reason why he shouldn't be granted this variance. It would have no negative effects whatsoever on any of the adjoining properties, especially mine. I'm friends with the former owner, and I've seen the hot tub and so forth, so I believe it's a reasonable request. I don't see why he should be denied.
Thank you so much.
You're welcome.
Okay. Anyone else? I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved in second. All in favor?
Aye.
Aye. Motion carries. Gentlemen in the back, if you can take it into the hallway, please. Thank you. Okay. All right. Next case is case 16678. Kevin Sawicbaum. I don't know what I did with that. 4 Riviera Drive, Smithtown, location southeast corner of Riviera Drive and Daphne Place, Smithtown, property zone R10. Request variance to reduce the minimum front yard setback from 40 feet to 24 for proposed 570 square foot addition and a 114 square foot deck extension. May I have your name, please?
I'm John Cox. I'm the builder for Mr. Zugbaum.
I need the applicant. Thank you.
Hi, my name's Kevin Zweigbaum. I live at 4 Riviera Drive, Smithtown.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. Now, would you like this gentleman to speak for you?
Yes.
Okay. You're going to have to use the mic, and you can
Sure.
take it out or lift it up.
Okay, no problem.
And I'm going to ask you to spell your last name, so tell me your name again, please.
John Cox, COX.
Okay, and your address, please.
My address is 20 Camp Drive, Selden, New York.
All right. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you. Want to tell us why you're here, please?
Well, we're looking to extend the kitchen about 10 feet into the front yard and to build a family room on the other front yard. And we need to ask for that the minimum setbacks be reduced in order to do that. There's an existing deck where we'd like to put the family room. There's already a variance that was approved for that when they built that. This is only going an additional 5 feet past that existing deck, and so we're just asking for that reduction in minimum.
Okay. Planning? Gentlemen?
No question.
Okay. Thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain motion to close the hearing.
So moved. Second.
And we're regularly moved in second. All in favor?
Aye.
Motion carried. Next case is case 16679, Carol Ann Seltzer, the estate of August Charles Seltzer, 15 Niagara Lane, Comac. Location, east side of Niagara Lane, north of Genovese Drive, Comac, property zone R10. Request variance to reduce minimum rear yard setback from 50 feet to 38 for an existing 266 square foot first floor addition.
Hi.
Hi, may I have your name, please?
Yes, it's Barbara Ann,
What is,
Barbara Ann Bundas, B-U-N-D-A-S. I have a power of attorney to represent
All right.
Carol Ann.
just wait, let me just
Sure.
make sure that power of attorney is okay. Okay, it is fine, so just say, do it again, please, your
Sure.
name and spell your last name.
Barbara Ann Bundas, B-U-N-D-A-S.
And your address, Barbara Ann.
19 Indiana Street in Hicksville, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Thank you.
Okay, here to request a variance to reduce the minimum rear yard from the 50 required feet to 38 to maintain a one-story rear addition that was built by Carol Ann's father in the early 70s. So we're asking to maintain it. It's been there since approximately 1972 or 3, she's not sure.
And this addition is a sunroom?
Yes, it's a full four-season room.
Planning? Gentlemen?
Thank you.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Regularly moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16680, Barbara and Allen Siegel, 9 Rutgers Street, Smithtown. Location, east side of Rutgers Street, south of Howell Drive, Smithtown. Property zone R10. Request variance to reduce the minimum front yard setback from 40 feet to 33. Reduce the minimum side yard setback from 12 feet to 7. Reduce the total side yard setback from 28 feet to 20 for an existing 352 square foot covered wraparound porch. Reduce the minimum front yard setback from 40 feet to 30 for an existing 6-foot fence. Increase the maximum permitted paved surface in the front yard from 25% to 33%. Increase the maximum permitted paved surface in the side yard from 25% to 35%. All right. May I have your name, please?
My name is Alan Siegel. I live at 9 Rutgers Street in Smithtown, New York.
All right. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you. You want to tell us why you're here, please?
I'm here to request a variance for a covered porch and driveway that I've already had done. Many homes in the area, in the development, have double driveways. Many homes have covered porches. It does not alter the character of the street. It doesn't detract from the neighborhood. In fact, it enhances it and raises the property values. The porch already exists. I have built it. I built it myself. It has no environmental impact. There's no gas, no electric, no water, nothing. And it enhances the value of the properties. The only thing that I could possibly change would be the setback for the fence, which is to buffer me from the crack house that I live next door to.
When you built this, you didn't feel you needed a permit?
I wasn't aware of the setback. I had done my measurements, but I was mistaken.
Planning? Gentlemen. That's all right. Okay. Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
It's regularly moved in second. All in favor?
Aye.
Aye.
Aye. Motion carried. Next case is case 16681, Salvatore Russo. It's 14 Terry Lane, Comac. Location: west side of Terry Lane, north of Hubble Street, Comac, property zone R10. Request variance to reduce the minimum front yard setback from 40 feet to 37 for an existing 29 square foot portico. Reduce the minimum side yard setback from 12 feet to 11 existing, and total side yards from 28 feet to 27 existing. for an existing 736 square foot deck with a 63 square foot roof over. Increase front yard paving from 25% existing to 30. Increase side yard paving from 25% to 40% existing. I'm sure, is there a power of attorney? Okay. May I have your name, please?
Mary Ellen Curtis.
Okay. Mary Ellen, you got to get that mic, please.
Mary
Spell-
Ellen Curtis.
Spell your last name, please.
Curtis.
Okay. And your address?
22 North Creek Road, Northport, New York.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
I do.
Thank you. Want to tell us why you're here, please?
I'm here for a couple of variances, one of which is to reduce the front yard, another which is to reduce the side yard, and the last is to increase the maximum side yard and front yard for paving. I'm not going to come up here and say that this was done for any other reason but for the fact that they wanted to improve their lifestyle. The portico was done so that when they went to the front door that there was a covering over the front door so that they were away from the elements. The driveway was increased because back in the 90s there was a car accident. Their car was parked in front of their house, and they live on a curve, and someone came on the curve and totaled out their car, so they decided to increase their driveway. And as far as the deck goes, it's only off by a couple of inches. And that's, so they're asking for relief. They're, you know, it was all brought on by themselves, and they would appreciate the board's.
Planning? Gentlemen? Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
Really moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16682, Dennis and Diane Kelly, 3 Navy Drive. Location, east side of Navy Drive, north of Marquette Drive, Smithtown Property Zone R10. Request variance to increase the maximum gross floor area of a lot from 25% to 28%, 27% existing, for a 56 square foot second floor addition. May I have your name, please?
Diana Kelly,
And your address, Diane?
3 Navy Drive in Smithtown.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
Yes.
You want to tell us why you're here?
I'm looking for an area variance to increase the maximum gross area. Unbeknownst to me, our house was over the limit already. It's supposed to be 25%. We're at 26.96%. The people that had the house before us, they did a dormer, and they got a C of O, but there's no variance for some reason. All I'm looking to do is just put reverse gables over the windows in the front and bump them out about 18 inches, and the one of them is going to go out at 4 feet. So it's really just for aesthetics to make the house look prettier, but my house is already too big, so just adding just a few feet puts it over even further. So that's really all I'm asking. It's not going to impact the environment, and it's consistent with other homes in the neighborhood, and it really shouldn't affect anybody. It'll make my house look nicer.
Planning? Gentlemen? Okay. Thank you so much.
You're welcome, thank you.
Is there anyone here that would like to be heard on this application? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Really moved in second. All in favor?
Aye.
Motion carried. Next case is case 16686, Machichi Living Trust, 89 Harvard Avenue, Smithtown. Location, west side of Osgood Place, Paper Street, south of Waverly Avenue, Smithtown. Property zone R10. Request variance to reduce lot area from 10,000 square feet to 6,500 square feet. I'll place them out. It's easier for you. It's easier.
Thank you.
You're welcome. I'm going to give this and this to David, I believe, too. Okay. Each have one? Yep. Okay.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. And I'm here tonight after a rather long journey through the bureaucracy in the town and the county. I'm just going to give you a brief history so you know where we're coming from. First of all, this is an application for a density right. If this board is so inclined to grant our application, all you'll be doing is allowing my client to sell the density right to, in this case, a doctor who owns a medical building in the town of Smithtown. The property that we're talking about will never be developed. In fact, what happens is a covenant is put on the property, and Mr. and Mrs. Machichi or the Machichi Trust could not do anything with that property. That includes putting a swimming pool on it, a shed, a tennis court, whatever. Initially, I want to call your attention, well, let me back up for a minute. So we had another contract, and that was with the Smithtown Fire Department. And at that time, we appeared before the planning board, and John Zolo, now the town attorney, then in private practice, represented the fire department. I represented Mr. and Mrs. Machichi. And again, the purpose was to allow Machichis to sell a development right to the fire department so that they could build an extension on their Comac facility. Well, what happened was the planning board granted us one unit. The planning board, which under our current statute or ordinance in the town of Smithtown, which I'm having a heck of a time trying to understand after hours and hours of reading it, says that the planning board has jurisdiction over this matter, and they did grant us the development right. We went through the whole thing just like I'm going to have to do tonight with you. The planning department, specifically Frank DeRubius, takes the position, well, you got to go to the Board of Appeals. There's nothing in the statute that says we have to go to the Board of Appeals, but what happened was when we went to the county and spoke to and wrote letters to Walter Hilbert, who's the chief officer with respect to development rights, he said, look, even though the planning board said yes, Frank said no, so you guys better get together because we're not going to move on it until you have a consensus. So at that point, we had a couple of alternatives. One was to bring an action against the planning board, but the planning board didn't do anything wrong. They granted us the development right. In conferences with the Machichis, they said, go to the Board of Appeals. That's what Frank DeRubius wants you to do, to show that this piece of property is entitled to one unit, unit meaning 300 gallons of flow. That's been decided already by the planning board. What this board has to decide is whether this back-to-back split or piece of property should be allowed to be developed. Now, the first piece of evidence that I'd like to submit is a copy of the property card indicating, if you look at the top is X'd out, but the bottom, the house, which is not the subject of this application, but which is in the front of the subject property, which is vacant, was CO'd, and the house property was CO'd. This vacant parcel had nothing to do with that property, and it never did. You can see from the property card that it was CO'd November 1st, 1960, and then there was an accessory building in 1971. So my point in submitting this is even the town didn't regard the vacant parcel, which is a separate tax map. As far as the health department is concerned, if the town of Smithtown didn't have an ordinance that made us come to them before we went to the health department would have granted this a long time ago because it's a separate tax bill and it's under a separate section. It was taxed probably since the 60s separately. So that's the first thing I'd like you to consider. The second thing is, which we're Exhibit B, is the survey of the vacant parcel. Now this vacant parcel, as you can see, is vacant. The survey shows it is vacant. It's wooded. It has never been used. The Machichis are here, and if you want them to testify, you can, that it's never been used for anything. It's just been held in the family. Perhaps one of their a child or the grandchildren would want a piece of property to build on. It's on a paper street. You can see Osgood Place is not open, so the request that we're making is we're never going to open the street and we're never going to improve the property. If you say yes, what happens is everything stays the same, and we sell the development rights and we keep the property, and all we can do is look at it. So the next thing that I'd like you to consider is Exhibit C, which is an aerial view of the subject property. You can see the Machichi home, and you can also see the piece behind it, which is vacant. And again, it shows that it's on a paper street. So there's nothing there that would require this board to look at it and say, wait a minute, this property was used in construction in conjunction with the house parcel. The next piece of evidence is Exhibit D, and that's a single and separate search, and that just speaks for itself. It's the same search we gave to the planning board. Again, the planning board approved our application, and it shows that the Machichis own no other surrounding property. Now, I'd like to call your attention, and you have as Exhibit E, two cases. The most important case, I think, for your review or for council's review is Burko versus Kern, our former chairman of the Board of Appeals. And basically, that case occurred in 1993, and it was after we had the 5 criteria. And basically, Kern and his board granted a back-to-back split. That's what this is. Property improved in the front, a vacant piece in the back, and it's commonly known as a back-to-back split. Well, anyway, somebody, a neighbor, I guess, brought an action saying that this board should not have approved the application. It was merged, and therefore you, well, not you, but the former board did not have a right to grant the variance. It went not only to the Supreme Court, but it went to the Appellate Division, and it was affirmed. That means that it was approved, as you well know. There's a second case that you can review, and that's a case that happened in the village of Bayville, which basically says the same thing. Now, your own statute, the single and separate statute in our town, and it'll only take me a minute to read it, basically, not basically, it says a nonconforming lot may be used, or a building or structure may be erected on such lot for use in accordance with all other applicable zoning provisions of this chapter upon approval of the Board of Appeals, provided that at all times subsequent to the effective date of the ordinance making such lot nonconformity, such lot has been separately owned and, in good faith, does not or did not adjoin any other lot in the same ownership, and does not and did not adjoin any lot in the practical or effective ownership. Well, wait a minute now. Look what the ordinance says. It says just what we would hope it didn't say, because it says if it's in the same ownership, it's effectively merged. But further, and this has been your rule for years, in Smithtown, a lot is deemed in single and separate ownership if one of two tests are met. One lot is not used in conjunction with the other, or the value and the utility of one lot does not enhance the value or utility of the other. It's on all squares, Madam Chairman and members of the board. The one lot does not, was not used in conjunction with the other, and the value or utility of the one lot doesn't enhance the utility of the other. And we meet this criteria. There's no driveway coming into the rear piece of property. There are no improvements on that rear property. The property, if it were developed, and if that's what we wanted to do, and assuming the board granted us that kind of variance, which is the same, which that's what we're asking for, then we could build a house there. But we don't want to build a house. All we want is this board to give us the go-ahead for density. That's what you see in your public notice. It specifically says density. So if this board was predisposed or disposed to granting this, all we could do with it is sell the density rights. We couldn't do anything else with it. The health department or the town would require us to covenant the property, which means nothing could be done with it. You could walk on it, you could smell the roses, but that's it. Can't build anything. I've explained that to Mr. and Mrs. Machichi. They understand that. They actually don't want to develop it. They want it to remain in its natural state. Some of the neighbors have called me and were concerned that it would be developed, and I told them no, it would not, that this is solely for a development right. And that's what we're here tonight, to ask for your favorable consideration. Would this be a change in the character of the area? There would be no change. It would look exactly as it did for the last 100 years. By the way, this map of Smithtown Lawns, I think it is, was filed in 1907. Whether the benefit sought could be acquired by some other feasible method. No, this is the best thing to do with this piece of property, and it hurts no one. Doesn't hurt the town. It doesn't hurt the county. It helps the county to the extent that this property will never be developed. There'll be no sewage going into the ground. Whether the requested area variance is substantial. Well, I guess maybe if we were building a house, but you've granted variances with 6,500 square foot properties before. But again, we're not asking for that, so we don't have any substantiality here. All of the single and separates that come before you should be for development rights, and I think it would be kind of a no-brainer to grant them. Whether the proposed use will have an adverse effect on the physical or environmental area of the property. Nobody's going to know the difference. There won't be a sign up, there won't be nothing. It'll stay the same. Whether the alleged difficulty was self-created, it wasn't self-created. I think when Machichis bought the property, they had hopes of giving it to somebody in the family to build a house. That didn't work out. But again, they don't want to build a house. They want to sell the development rights. So we think it's a great opportunity for this board to move forward with this. If this board grants this application as the planning board already did, then the next step is just to go to the health department and show them that we're now in sync. Because before that, they said, you guys better get together, the planning department and the planning board. So that's where we are. It's probably been a year and a half, 2 years since we started with this, and you're kind of the board of last resort here. We've done what Mr. DeRubius wanted us to do, and hopefully you'll do what we feel is the right thing. Thank you.
Okay. Planning?
Just a few comments, Madam Chair. The Planning Department recommends approval, but before getting to that, I think it would be helpful to mention two things. First, for the benefit of the Machichis and Mr. Tremarco, if the board grants this, they need to actually go back to the planning board, because under that chapter, it's a two-step process. The first step is the planning board determines the gallons or the amount of flow rates. They just determine how many a parcel would generate. And if they come up with an answer of like a half or 1 or 50 or whatever it happens to be, then the second approval under the town code is the planning board has to approve where they're going to. In other words, first, let's just take a hypothetical parcel where they say, oh, we find there are 20 rights over here. Well, that's just determining how many rights there are, and that's what happened last summer. The second step is there's a transfer, and it goes from property 1 to property 2. So they do need to go back to the planning board to get approval for the transfer itself. The second thing is the planning department recommends that this application be treated like other area variance applications. And the reason is that if the town and the county had two sets of standards, one where you can't build on the property if you want to build on the property, but you could build or you could get development rights if you want to build somewhere else, would result in a net increase in pollution to the groundwater. Because if you weren't allowed to transfer the density flow rights and it only could stay in the property from which they come, if you can't build there, you can't build there, and the groundwater pollution is zero. But if you take the 300 gallons and move them somewhere else, but never had the right to them to begin with, you're now increasing the pollution loading to the water table. So that's the reason that we recommend looking at this like normal area variance applications. With that in mind, we did look at the 5 considerations. And while the request is substantial, when you average the subject parcel and the Machichi's other property, they average around 7,000 square feet each, and that's a 30% reduction in the the density in the area. However, when you look at the whole area, even though the request is substantial, there's very little impact. The neighborhood's around 54 acres. It has about 220 homes on it. The average lot size is about 10,000 square feet, interestingly enough. It's, the mean and the median are very close to each other. One's about 9,800, I think, and the other is around 10,200. And it would seem to indicate, gee, this neighborhood really complies a lot. But if you generate a scatter diagram or a bell curve type of a graph, you'll find that there's actually a large distribution or a wide distribution in lot sizes. And the character of a neighborhood, we believe, is not based only on the median. It's really, you know, what's in character, the middle third of the sizes, the middle 99% of the sizes. I think if you went to an academic institution, they would probably say 2 standard deviations from the mean. And that means basically everything in the middle 95% of the lots would usually be considered in the bulk of the curve. This curve looks like it has a normal distribution, you know, for basically a sample. This property is well within that mean. So developing basically, or basically having a density of 70% of the requirement in this neighborhood, we would contend is not out of character. Does it have an environmental impact? The Department of Environment and Waterways looked at this and they gave you a recommendation that this is a type 2 action. And under New York State environmental conservation law, anything that's a type 2 action is legislatively deemed not to have an impact on the environment. The second half of that question, it says environment or physical conditions. It really wouldn't have any impact on traffic, in the area or drainage. The last thing is it's self-created. Technically, it is. I mean, if the Machuchis bought the property when the zoning didn't allow the property to be built, they created their own hardship. Now, maybe it wasn't malicious, but they weren't shrewd business people, and buying only properties that met all the zoning. However, in our opinion, the fact that it might be self-created is tempered by the fact that there's no impact and there was no malice as far as we can tell. No one tried to circumvent the town law or defy a stop work order or anything like that. So when you put all of the factors together, we recommend approval.
Okay. All right. Gentlemen, anything? Any questions?
No question.
Okay. Thank you so much.
Thank you.
Okay. Is there anyone here that would like to be heard on this application? All right. Mr. Chalker, you do understand you have to go back to the planning board? I guess so. Okay. All right. I'll entertain a motion to close the hearing.
So moved. Second.
Very moved in second. All in favor?
Aye.
Aye. Motion carried. Okay. I'm going to put everything in here. Just we'll clean it out tomorrow. Okay. We'll put everything in and we'll clean it out. Okay. Next case is case 16684. Bernard Bibiano, 4 Jeffrey Lane, Kings Park, location. It's outside of Jeffrey Lane, west of Boxwood Drive, Kings Park. Property zone R10. Request variance to increase the gross floor area of lot from 25% to 29%. Proposed 1,057 square feet addition. Reduce the minimum front yard setback from 40 feet to 39 feet for proposed porch. Okay, just wait 1 second until they clear. May I have your name, please?
My name is Bernard Biviano, Biviano.
And your address?
My address is 4 Jeffrey Lane, Kings Park, New York, 11754.
Okay. Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay, you want to tell us why you're here, please?
Yes, I request a variance to increase the floor, gross floor area of the lot from 25 to 29%. What I plan to do is move the bedrooms from the first floor to the second floor, adding 2 bedrooms to the second floor with an additional bathroom upstairs. Increasing the living space on the first floor with a den and...
Wait a minute. Can you get it? Slow down and go ahead.
Oh, I'm sorry.
You okay?
Talk too fast. One of the problems I have. All right, I'm going to be putting 2 bedrooms upstairs, and in doing so, that permits me to give myself a bigger living space on the first floor, which would be a den, dining room, and a little more functional in the house with the kids. Also, I propose to put a portico on the front, which increases the setback from 40 to 39 feet. And basically, it doesn't impact anything in the neighborhood whatsoever. I already have bedrooms upstairs on the second floor. I'm just going to be adding on 2 more. And that's pretty much it.
All right. First of all, let me just tell you, we view these sites. We go to these sites.
Yes.
And I'm looking at your plan. Can you tell me why you have a second door and why is that going to be an apartment?
Downstairs?
Yes.
Yes, my brother-in-law actually lives with us. He lives downstairs.
Okay.
Yes.
Okay. Now I think there's no data problem, John, as far as...
Well, if he wanted to go through with it, he would have to do the special exception for a family member living at home.
Do you have a separate kitchen there, or is it?
No.
You live as one family unit?
Right.
Is there access throughout the house?
Yes. It's all open.
In the building department eyes, we would look at that as a one-family dwelling.
Right.
And we would ask the applicant to give us a letter that, one, our records show that, and it would continue to be a one-family dwelling.
Yes.
Chair?
Yeah.
I think it might help your concern. I think the front elevation maybe makes it look a little bit more like a multifamily house. I think a garage was converted to living space and there's no garage. I think this is that application? we
Yes,
were
there
talking
is
about?
no garage.
Right.
And
And the siding, I think, is proposed to go all the way down to grade, and I think it makes it look more like a multifamily that way than it did, or like other houses in the area where the siding starts at a higher level.
Well, I think my concern was also that there's a staircase, but it's closed off to the rest of the house.
Is
Am
it?
I correct?
It's been a while since I've looked at the plans. I don't
Am
remember.
I correct?
No, it's open.
There's no door or anything?
There is a door there, yes.
Are you suggesting maybe a different treatment to the front of the lower portion of the house to make it appear more like a single-family residence?
That's my that would be my recommendation. There seems to be concern, and I guess that the concern is, I think, also legitimate. I mean, not just because you're the chairperson, but the concern's legitimate in terms of, while he might have the best intentions of the world, someday we're all going to sell our home, or at least hopefully we are, and you don't want it set up so that some shark comes over and says, boy, I could put a lot of families in this. It's all set up for it. So if it has a little bit less appearance from the street of being a multifamily,
Well, I don't mind putting the garage door back and open it up. I really don't have a problem with that. I mean, if that's an issue,
I don't know, I just meant from a,
you know.
like I said, you may have the best intentions of anybody in the whole
Right.
town of Smithtown, but someday, someone's going to buy that property, and they may not have the same intentions you have tonight.
No, I understand.
So if it looks a little bit more like a one-family or less like a two, I think that might help out the neighborhood more and the future of the town a little more. Not the interior, but the exterior.
Right.
Was this house, was there a fire at this house?
Yes. There was a fire there. We're rebuilding it again.
Any other questions? Gentlemen, any other questions? Okay, thank you. Is there anyone here that would like to be, be heard on this application? Okay. May I have your name, please?
Sure. My name is Frank Guidice, Guidice. I live at 2 Jeffrey Lane.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do. I live at 2 Jeffrey Lane. I've been there for, I don't know, 100 years, 35 maybe years. That house has changed since I've been there. There was a garage in that house, as you pointed out. It's closed. It's a single front door to that garage. It's been that way for quite some time. There was an extension added to the back of that house at one point in time, and I have certain safety concerns, particularly after the fire, because our homes are on a quarter of an acre, as you well know. Our houses are very close together, so I have some serious safety concerns as to what's going to transpire next. Not only was there a fire there, unknown origin, I don't know how the fire, nobody ever shares that with us, but there was a second fire up against the pole only maybe, I don't know, 2 months ago, electrical. And we do share the same pole, so I am concerned about safety. That's my primary concern. It's very difficult for us to picture what's going to happen here on the basis of this small blurb that we get from our neighbor and from you as to how this house will change once again. I'm not quite sure. My house sits probably about 4 feet lower than my neighbor's home. The topography in the area is very hilly, as you know. My house is on the bottom of the hill, so he's 4 feet over me already. Now, I don't know whether when you add a significant extension on the second floor, we're going to change the exterior of that house one more time. I don't know what the height of the roof will be. I'm not sure if I'm not going to feel like I'm living next to a skyscraper at the present time. Once that changes, I really don't know. I have no building skills, and I certainly have not seen the plans. As I say, there was an extension in the rear of the house that's been removed since the fire. I don't know if that's going to be placed back on, if that's part of the plan or it's not part of the plan, and are we diminishing this stuff? I mean, it's starting to feel like I live in Queens. So I do have certain concerns. The project's been underway for a significant period of time. I'm not quite sure, what the delay is, although I do believe that my neighbor is doing the work himself, and I know that that takes time. I've done things in my own home, and I know, and this is a tremendous undertaking. But once again, I've seen the crew. It's himself, and I think they're 2 day laborers, one that can't find the bathroom, unfortunately, and urinates in the backyard. That's annoying, Tom. I can tell you that. I'm concerned about the length of time that this project will take. I am sympathetic. I do know he had a fire in the house, and, these things, by the time you get done negotiating with insurance companies, et cetera, and the town submitting plans, and you have obviously done some of your homework because you've seen some of the issues that I'm sitting here right now, standing here, presenting to you and some of my concerns. And again, we're in the dark. I can tell you, while I speak for myself and my wife, my neighbors have voiced their concerns to me also. One of my neighbors is sitting there. She lives across the street, but people are concerned. We don't know whether our neighbor has an intent of changing this house from a one-family dwelling to a multifamily dwelling. As I say, this is a significant extension. And again, my primary concern is what's this going to do for sunlight. The character of the neighborhood's definitely going to change. There's no doubt in my mind, because these properties are small. These houses are big, and were designed big at the time that they were built. So I don't know, how I resolve my issues, or, how somebody can explain to me what's going to happen there, so that I can say that I can live like this, But these are my concerns, and, I just wanted to express them here tonight, because I would have felt very foolish if I just sat back, watched the house being built, and then be unhappy about it and trying to change things then. So I understand his right to do the things he wants to do. He just wants to be happy in his home. But I've been there many, many years, and I just wish to be happy in mine. So thank you very much for your time.
Just let me tell you, the height of the home is 33 feet.
Mm-hmm.
And he's allowed 35 to the top of the roof, and he's at 33.
So that would be 35 at the time. The total height would be 35 after
33.
the extension.
It'll be 33 feet.
33 after the extension.
Yes.
And there are no other extensions. He's not going to extend beyond the framework of the house. Is that correct?
You see anything? No.
Just the top.
Okay.
I like the fact that you're asking for a letter that's going to indicate this is going to be a single-family dwelling.
Okay.
That's it?
Anything else? That's it.
Thank you.
Anyone else? Right. Come on back, please.
Yes.
It has been done before, and we have done it. I know you have a trailer, and you have a couple of trailers on there. You have a storage trailer.
Yes.
And a construction trailer. Now, I don't know how the other board members feel, but we have put timelines on to when this house has to be done.
Right. Well, I can tell you that the interior right now, as it stands, is just about totally rebuilt inside. The only thing I'm waiting for now is the okay to pretty much take that second half of the roof off and build those 2 rooms up on top. And then as soon as that's done, which will probably take about 10 days at the most, then the house is going to be roofed and sided. We're talking about maybe 2 months at the most, because the insurance company also wants to take their trailer away. And, the ongoing problem, and also answering Frank's problem with what happened.
All right, address this board.
Oh, I'm sorry, was that the FiOS battery backup box shorted out and caused the fire in the house, and that's what basically happened to that. The second fire that occurred was when Keyspan came out, National Grid, and they investigated why the pole went on fire. Was because now we have a trailer that basically uses only electric for heat, hot water, and everything else. So what happened was one of the legs up on the pole was loose, and that caused a short, and that basically had that go on fire. And they came and put a whole new line in and so on, fixed that.
Okay.
All right.
All
Thank
right,
you.
Thank you. Any other questions? Okay. All right, I'll entertain a motion to close the hearing.
So moved. Second.
It's already moved in second. All in favor?
Aye.
Motion carried. Next case is case 16685, Maria Tripoli, 92 Washington Boulevard, Comac. Location, it's outside of Washington Boulevard, west of Fulton Boulevard, Comac. Property zone R21. Request variance to reduce the side yard setback from 16 feet to 14 for an existing 176 square foot deck. Your name, please?
My name is Maria Tripoli. I live at 92 Washington Boulevard in Comac.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
I do.
Thank you. Would you like this gentleman to speak for you?
Please, yes.
Thank you.
My name is John Teufel, T-E-U-F-E-L, professional engineer, 707 Route 110, Farmingdale, New York. We're here tonight requesting a side yard variance.
Yeah, you raise your right hand, please.
Oh, sorry.
Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you. Go ahead.
We're here requesting a side yard variance to maintain 176 square foot wood deck attached to the front of the house. It's really more like a front porch. The zone is R21, where a 16-foot side yard setback is required, and we are requesting to maintain the existing deck side yard of 14 feet. The height of the deck is 3 feet 6 inches above the grade. It only extends about 18 inches past the side of the existing house. The deck existed when Ms. Tripoli purchased the home in September of 2011 and appears to be in excess of 10 years old. $7,000 is being held in escrow pending the board's decision this evening. Regarding the 5 questions, there will not be an undesirable change produced in the neighborhood. It's simply a front porch. There's many of those. The benefit really can't be obtained any other way. Again, it's an existing structure that was there when she bought the home. She had no idea that it was encroaching on the side yard. We don't believe it's a substantial variance at all. We're only going, again, 18 inches past the house, or 2 feet out of the 16 required into the side yard. We don't feel the variance will have an adverse effect. Again, it's simply a front porch, a wooden front porch, basically, and there's many of those in the area. And the difficulty was not created. Again, the deck existed, and Ms. Tripoli was kind of an innocent party. She didn't know that it needed a variance. And that completes our case.
Planning?
No comments, Madam Chair.
Gentlemen?
No, no. No question.
Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Motion really moved and second. Motion carried. Okay. Next case is case 16686, Joseph Brescia, sorry. 17 Cornelia Lane, Lake Grove, location, northwest corner of Cornelia Lane and Christie Lane, Lake Grove, property zone R10. Request variance to reduce the minimum front yard setback on Christie Lane from 40 feet to 0 for a proposed 6-foot fence. May I have your name, please?
My name is Pierre D'Alessandro, 18 Sussex Lane.
Do you have a power of attorney?
I do.
Okay, thank you.
You're welcome.
Would you spell your last name then?
D'*ALESSANDRO.
Okay. Raise your right hand.
You want my
swear
address?
to- Pardon me?
My address?
Yes.
18 Sussex Lane, Lake Grove, New York, 11755.
Okay. And raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Okay. As I said, my name is Pierre D'Alessandro. Can you hear me well?
Yes, we
Okay.
can. Thank you.
You're welcome. I'm acting as agent for Joseph Brescia, who resides at 17 Cornelia Lane in Lake Grove. Joe is also my neighbor. I live very close. Joe and his wife, Jeanette, are the original owners of the house, and they are requesting a variance to reduce the front yard setback on Christie Lane from 40 feet to 0 for a proposed 6-foot vinyl fence. Currently, there is a 4-foot fence that's existing with a very large overgrown hedge that's been there for approximately 30 years since they bought the house. They were the original owners of that home. They bought it in '73. They wish to remove that 4-foot fence that's there now and put up a 6-foot fence to get rid of those hugely overgrown bushes. The bushes are grown into the yard approximately 9 feet, and they extend over the existing sidewalk. I have some photographs, if I can bring them up and show them to you.
We have the photographs, and we were there.
Okay.
Mhm.
Okay. So as you can see from the photographs and the visit, that the bushes are extremely overgrown and they are eating up a good portion of the backyard, leaning towards the pool that is existing there. There is an in-the-ground swimming pool which is located in the front yard, which they do have a CO and they had gotten a variance for, and they do have a CO for. As you can see, Joe and his wife have gone through the proper channels to do many of the things they have done at their homes, including that pool, including an extension, and currently there is a permit that has been, excuse me, that's already been granted, and there is a shed that has been built on the property, and it's already been passed and everything. We're just waiting for the assessor's office for that. They've been doing everything the right way, and basically what they're looking for is to get some room back in their yard. It's been over 30 years that those bushes have been growing into their backyard, and it's just gotten a little out of hand. They currently have 3 grandchildren who she watches every day, and the fence that they're asking for would provide the privacy and safety for those grandchildren to be in the backyard and make her feel comfortable that there is, you know, a good protection to the exterior of the on the street that lines up right with the backyard. Right now, there is, like I said, the pool that's there is existing, and it has a CO, and everything's in place. The plumbing system for the pool, for the filter and the electrical appliances for that pool are 4 feet away from the existing 4-foot fence on the inside of the yard, which, again, this has all been CO'd. They have their proper paperwork in place for that. There is basically only 4 foot from the curb, from the sidewalk, I should say, to those appliances that are there, the filter, the heater, and the electrical devices that maintain that pool. Again, that pool is legal. As far as an undesirable change in the neighborhood, I don't think it will create any undesirable change because, like I said, if you've seen the pictures and you visited, it's an undesirable look right now. It would make for a more desirable look if the fence was to come down and the trees would be cut and put up a new decorative fence along that particular stretch of Christie Lane. Also, the house does not face, that portion of the road, of the yard, does not face any homes. It's to the side of, I think it's number 15 Cornelia, so it does not face any home. No one is looking directly at that. My house also faces Christie Lane, and that also has a 6-foot fence, which was granted by the board on that same exact stretch of street rather. I have a 6-foot vinyl fence on top of I believe it's about a 30-inch retaining wall, which was granted through a variance by the town of Smithtown, or else I wouldn't be telling you. But there are other properties in the area that do have the same situation with 6-foot fences along the sidewalk. I do have some photographs, if I can maybe bring those up and show you.
Do you know if any of those homes have permits or CO?
Those two I do not. The one I
Okay.
just told you does. The one on 18 Sussex Lane, which is my home, does. And that I have photos of if you'd like me to bring them up and show them to you.
Well, you would have to have them labeled and you would have to tell
Yep.
me if they have permits or not.
Well, they are labeled, and it's my home. It has
Okay.
permits, variances, and I could bring them up and show them to you if you like.
Okay, you can do that if you like. Thank you.
As you see, there's a brief description of what you're looking at. It's my home. It faces directly across the street, or just a little bit askew from Joe Brescher's house. Both facing side. All 3 homes in that area the sides face that area, that whole block basically. Like I said, if someone's been there, knows there's no homes facing that particular area. So as far as an undesirable change, I go back to that. I don't think it would produce an undesirable change. Like I said, it would look better. One second. The benefit can't really be achieved by any other means, because to get the privacy that they've gotten accustomed to after living there for 40 years, you would need something a little higher than the 4-foot fence that the town lets you put up. And since those bushes, they're so overgrown and really need to come out, you couldn't replace that with, you'd have to put in totally mature bushes, which would be a fortune to do and almost impossible to get in there and achieve that same effect that a 6-foot fence would do. As far as the variance being substantial, although it may be substantial in some people's eyes, it has been granted many times in the neighborhood, and myself being someone who can testify to that. There are many fences, whether they've been granted or not, that are in that same current situation on corners. Mine also surrounds a pool, which I have a variance. The town was good enough to give me the variance for my fence and my pool. So I basically have the identical situation that Joe does, and it was granted by the town and the board. So again, I don't think you can really achieve that by just putting in a 4-foot fence. And I'm sorry, that was the substantiation. And as far as an adverse effect on the physical environment or the conditions of the neighborhood or the district, again, this area faces no homes at all. There's so many fences and properties that are bordered with 6-foot fences on corners. And again, the current situation occurs directly across the street in my home. So I don't think it would actually have any adverse effect or negative impact on the physical environment or the conditions of the neighborhood. And if you ask if it's self-created, I guess due to over 30 years or so of maybe not properly maintaining those hedges or just general overgrowth, I don't think you can actually even maintain a hedge for 30 years or 35 years to actually keep it under control and keep it kempt. I believe, although it may have been self-created in some people's eyes, overgrowth and that length of time, it's kind of hard to do that. So I don't think it was no malicious intent. He didn't decide to let the bushes grow wild. He just basically got a little bit out of hand. So that's basically it.
Thank you.
I think that's about it.
Planning? No comment. Gentlemen?
I just have 2 quick questions.
Sure.
Do you recall how far off the property line the board required you to keep your fence for your approval?
I believe it was impacted because it was on a wall also. So I think 6 foot, I think. I'm not quite sure. I can't remember. It's 7, 8 years, going back 8 years or so.
What's the address?
18 Sussex Lane, Lake Grove, New York.
And the other question is, were the arborvitaes that you planted in front of it a condition?
Yes, that was a condition, absolutely. And those were about 4 foot tall, and you could see the growth at about 7 or 8 years have done. I do plan on maintaining those so they don't get out of control. But also, as another point that you brought up, and I'll discuss, he is willing, obviously, I've discussed it with him, that if he was not able to get right on the sidewalk, which, reality, if that's the case, he could roll it in a few feet and then put a nice row of the same kind of bushes to maintain that, look, so that the white fence isn't so stark, and that's basically what I did on my property. The only problem there is the depth, or how far in he could actually come, is impacted by those appliances that are already in place. He's got the filter, the heater, the electrical outlets that come out of the ground for the pool. Those are all there, and for him to have to move those, it would be a tremendous expense, and that would be, I would consider, a hardship. So
Do you know exactly how far they are off?
it's 48 inches. I measured it myself. The electrical, the electric piece that comes up, because you have to have electrical far away from the pool. It's got to be a certain height. That's the closest, and then right beyond that, you have the filter and the other appliances that are there.
Okay, thank you.
Okay, and again, just to reiterate, all that was done with the variance. I'm sure you have a copy. I have a copy here, but it's all done and approved by the board.
Thank you.
Okay?
Thank
you very much.
Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Regularly moved and second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16687, 45 Mall Realty LLC, 45 Mall Drive, Suite 5, Comac. Location, north side of Mall Drive, west of Moore Lane Road, Comac, Property Zone LI. Request a special exception to maintain a daycare center. Variance to reduce the number of landscape aisles from 45 to 17, 17 existing. Reduce front minimum parking setback from 50 feet to 12. Permit environmentally sensitive land to be altered. Slopes greater than 15%. Reduce setback from environmentally sensitive land from 10 feet to 0. Increase retaining wall height from 4 feet to 6. Reduce setback for a 6-foot high retaining wall from 6 feet to 0.
Good evening, Madam Chair, members of the board. My name is Anthony Guardino. I'm an attorney with the law firm of Farrell Fritz PC in Uniondale, New York. I represent the applicant 45 Mall Realty LLC, which is seeking the area variance relief that you just mentioned, and a special use permit in order to maintain certain existing uses in its building that is located at 45 Mall Drive in Comac. Just some housekeeping, if I can just submit the affidavits here.
Oh, yep, right. Take good. Oh, wait a minute. Wait a minute. This is May. May. Okay, that's all right. Can you share? And we can share? That's fine.
Shall I proceed?
Yeah, go right
Okay,
ahead.
thank you.
We're just making sure we have the May ones.
Okay. Do you have the right plan?
I believe we do. I don't think that's, I think that's it. The May, no, wait a minute, I don't know if that's it. Yeah. I think you need this to look at. All right, well, do you have it? No. You don't have it either. Okay.
You want to look at the April?
Should we look at is the April different?
Mike, is the April plan any different?
We say survey and site. So some people are looking at the survey. Some people are looking at the survey and some are looking at the site plan. That's why
I think we only have 2 copies of this. That's all we have. These are the retaining walls. You only handed in 2 copies? Is April the right one? Okay.
There are 3 that look similar to each other and 1 that looks different, plus floor plans. But I made sure that I kept the right number of the right plan.
This is stamped May, is that all right? I guess that's all right, received in May. Is April 25th the right one?
Well, the difference between the original submission and the newest one is, when it's that scale, is the newest one has the topo on it, really. That's the main difference.
Okay.
Okay.
Go ahead,
All right, thank you. All right, I also have with me tonight Michael Marinas, professional engineer with Barrett, Bonacci, and Van Weel, Philip Monastero, an architect with Monastero Architecture, and Anthony Raccanelli, who is a principal of 45 Mall Realty LLC. If the board has any questions, we can draw upon them. The the property is a 7.09 acre parcel of land. It's located on the north side of Mall Drive, approximately 293 feet of Moreland Road in Comac, and that is located in the John Klein Industrial Park. The property is a single tax lot identified as Section 179, Block 1, Lot 19 on the Suffolk County tax map. The property is a through lot, as you can see from the site plan. It is a through lot which has 451 feet of frontage along Mole Drive to the south, and then an additional 454 linear feet of frontage along the Northern State Parkway to the north. That's up here. The property was improved in the late 1980s with a approximately 91,000 square foot one-story building and a parking lot that currently provides parking for 274 vehicles. However, once the proposed site improvements are completed, the site will accommodate parking for a total of 330 vehicles, which satisfies the town's parking requirements. Property is located within the town's LI Light Industry Zoning District, which expressly permits the existing warehouse and office uses and the existing daycare use by special exception from this board. As presently configured, the building contains slightly more than 12,000 square feet of office space, slightly less than 50,000 square feet of industrial use, and slightly less than 30,000 square feet of a New York State licensed adult daycare center. The properties that surround the subject property to the east, south, and west are all zoned light industry, and they permit light industrial uses such as warehouse, manufacturing, and office space, all of which are located on Mole Drive. And then the Northern State Parkway is located to the north of subject property, and that's zoned CF Community Facilities. This aerial might be helpful if I could just hand it up. Just shows the surrounding properties and also the proximity to the Northern State Parkway.
Okay, perfect. That's all right, we'll pass this.
The 45 Mall Realty is seeking to legalize approximately 6,000 square feet of office space that was converted many years ago from warehouse space, and then also to maintain the adult daycare center that actually received a certificate of occupancy from the town several years ago, even though a special exception had not been previously obtained from this board, as was required by the zoning ordinance. So now the applicant is before this board seeking the special exception relief or approval, I should say, kind of just by way of some housekeeping, just to make sure that the paperwork has caught up with the use that's there. And also several area variances that are needed in order to permit certain parking and site improvements that are required to accommodate the previously converted office space. What I'd like the board to note at this time is that the applicant is withdrawing its request for two of the variances. That's the variances from section 322-19, subdivision C, as in cat, and 322-19, subdivision E as in Edward. And those variances were originally triggered by the belief that there was environmentally sensitive land on the subject property. And that, when I mean environmentally sensitive land, I'm talking steep slope lands. But it has since been determined that the portions of the site that have steep slopes or slopes greater than 15% were not naturally occurring, but rather were created when the property was originally developed. And as these areas are not deemed environmentally sensitive, the variances from these sections are no longer necessary. So we'd like to withdraw our request for those two variances.
All right, so the variances that, let's see, permit environmentally sensitive land to be altered, is that the one?
That's correct.
Okay.
And the one below it.
Slopes greater. And reduce setback from environmentally sensitive land from 10 feet to 0?
That's correct. Since there's no environmentally sensitive land, we don't need the setback variance. However, the applicant still needs four area variances, in order to maintain the existing uses. The first one is to reduce the number of landscaped islands from 45 to 17. There are 17 existing. Also a variance to reduce the front minimum parking setback from 50 feet to 12 feet. The variance to increase the retaining wall height from 4 feet to 6 feet, and the variance to reduce the setback for a 6-foot high retaining wall from 6 feet to 0 feet. I just want to point out with respect to the second and fourth variances where we talk about the setback issue. If I may point out, yeah, the setback issue is created by this very unusual boundary of the Northern State Parkway. I'm not quite sure why this is here, but it is. You see this jog of land? This belongs to the state. So this is actually the Northern State Parkway right-of-way, and it actually comes right to our property line. And because we have, this lot is a through lot and has two frontages, this back is considered a front because it's on a road, and therefore we don't have the appropriate setback. So this is what we're talking about. This is what's triggering our problem. And that's for the retaining wall and also for the parking setback. If you apply the 5 factors of the town law, section 267B, we believe that the granting of these area variances is justified because the benefit to the applicant far outweighs any detriment to the neighboring properties, which will not be impacted because the applicant is merely seeking to maintain the status quo and to make improvements that are located behind its building, and these are improvements that will not be visible to any of the adjacent properties. And it's for that very reason these improvements in this application, and if the variances are granted, there would not be any adverse impact on neighboring properties or the community, which is the first factor. The second is because the proposed improvements are necessary to allow the applicant to maintain the existing uses of the building. There really are no other feasible alternatives for the applicant to pursue short of requesting the variances. With the exception of the variances for the parking and retaining wall setback, the requested variances relate to a modest increase in the height of the rear yard retaining wall and the parking islands, and therefore we believe they are relatively insignificant. And while the parking and retaining wall setback variances appear on their face to be significant, they are caused by this very irregular shaped boundary that I pointed out earlier. So that's what's creating that. So they look significant, but we believe they're still insignificant because of what they represent. And then finally, the requested area variances would not have any adverse impact on the physical or environmental conditions of the property or the surrounding area. And then with respect to the special use permit, I would submit that the proposal to maintain the adult daycare facility, which again, as I mentioned, already has a C of O, should be granted because the facility meets the 6 specific standards for daycare special use permit, and also the general standards for special exceptions as set forth in Town Code 322-94G. But rather than go through all of those standards, I'm going to defer to the findings that were made in the Planning Advisory Report dated May 2nd, 2012, which was prepared and submitted on behalf of the town's planning director, which I believe you have. So rather than repeat what's in there, I will defer to those findings. And I have nothing further. Now, I have an engineer here. I have an architect. I don't know if the board would like to hear them, if they have any questions, or if you'd like to hear their presentations.
Let me just say to you that you know there's no action.
I understand that.
Do you realize that they think that the sewage, you have to go to the health department?
Yeah, well, you know what, I'd like to, can I call up the engineer to address that?
Good evening. My name is Michael Marinas. I'm the engineer for the project. I did look.
Just spell your last name.
Sure, I'm sorry. It's Marinis.
And
I'm with the engineering firm of Barrett, Bonacci, and Van Weel, 175A Commerce Drive, Hop Hog, New York.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
I received the letter that you're referring to, dated May 2nd from the Town Department of Environment and Waterways.
Right.
And I reviewed the current Health Department code with regard to sanitary density and allowable flow for that property. The property is 7.3 acres in size and has an allowable sanitary flow of 600 gallons per day per acre, which is a total of 4,380 gallons per day. The site presently generates 3,587 gallons, given the 12,000 square foot office, 49,000 square foot industrial space, and an estimate of 177 people at 5 gallons per day per capita for the daycare. So the total is 3,587, which is less than the allowable flow of 4,380 gallons. We understand that we'll have to get an approval from the county for that, but we do have, we are comfortable that we meet the criteria and the requirements for from the health department.
Okay. Do you have any, you want any other architectural?
No, thank you. I just wanted to let you know the planning department prepared a planning advisory report, and I think you all have it. We recommend approval on all of the applications except for the two that Mr. Guardino withdrew. Basically, even though the daycare center has a CO, it doesn't have a special exception, which the zoning ordinance requires. So we looked at it as though it's not there yet. And it, in our opinion, meets all of the general and specific standards for all special exception uses and those for this special exception use.
Thank you. Gentlemen, is there anything that you would like?
No questions.
Okay, you're fine. Okay, thank you very much. Thank you. Is there anyone here that would like to be heard on this application? Hearing now, I'll entertain a motion to close the hearing.
So moved. Second.
It's regularly moved in second. All in favor?
Aye.
Aye. Motion carried. Good night. I think this is two. Yep. Tom, you want to tell this gentleman, I think he's waiting for a decision on that house, and there's going to be no decision because there's no action. Yeah. I know, it's the gentleman with the house that is with the trailer and everything. There's no action, so I don't know if he's waiting for a decision or not. It's up to him. But the next case is case 1-16656. It's re-advertised, GDF Realtor Don's Hand Car Wash, 762 Smithtown, bypass Smithtown. Location, west side of Southern Boulevard, north of Smithtown bypass Smithtown. Property zone, WSI. Variance to increase the number of wall signs from 1 to 2. Permit a wall sign not to face a public street. Increase the max area of 2 ground signs from 32 square feet to 137 square feet, and from 32 square feet to 72 square feet. Increase the maximum height of ground signs from 15 feet to 19 and 15 feet to 17 feet. To permit the location, a sign not be on the applicant's site. Increase the height of an awning sign from 12 feet to 13. Permit 2 awning signs with the flaps greater than 8 inches to 12 inches. Permit 2 awning signs with writing on other than the flaps. Permit 2 awning signs with other than constant pitch. Permit an awning sign not to face a public street. Reduce the rear yard setback from 50 feet to 40, existing steel and canvas tent. Reduce the rear yard setback from 50 feet to 28, existing awning. The rear yard setback from 10 feet to 0, existing vacuum on concrete pad. I don't think that's needed, is it? That variance? Okay. Thank you. Go ahead.
Good evening. My name is Carmine Grasso of Cataldo Grasso Architects. Our office is at 14 Carl Avenue, Smithtown, New York. I submitted the mailing and posting affidavits and the power of attorney.
Okay. Can you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay. Oh,
No, it should be in that folder there.
No, there's no, this is memorandum. Is there one? Is there? Thanks. Okay.
Thank you.
Okay, you raise your right hand. Yes. You swear to tell the whole truth and nothing but the truth?
Yes.
Okay.
I represent GDF Realty in their application for variances at the Don's Car Wash site on Southern Boulevard in Smithtown. Just to give you a brief history of the site, the site was once part of the gas station site, which is located on the corner of Southern Boulevard and Smithtown Bypass. The properties were split sometime in the 1990s. After the split, the address of the subject site, the car wash site, actually remained as 762 Smithtown Bypass, even though the property doesn't front Smithtown Bypass, it only fronts Southern Boulevard. As you can see, we're requesting a number of sign variances and some variances for two built prior structures. We reviewed the rear yard setback variance for the existing vacuum with the building and planning departments, and it was determined that the vacuum was on a previously approved plan, and therefore a variance is not required for that. I handed you an as-built survey and revised denial that we received from the planning department or from the building department after the advertisement went out. The variances requested for the existing structures are for rear yard setbacks for a canvas tent and an awning. Both of these structures are on the north side of the building. The principal building is 28 feet from the rear property line, and the tent is attached to the building and is set back 40 feet from the rear lot line. The awning runs along the north side of the building and ends at the rear wall. Both of the structures are within the previously approved building setbacks, so neither of them project back further than the existing building. As far as the signs go now, we're requesting a variance for a second wall sign that does not face the street. This sign faces the parking and queuing area on the south side of the building. When the two properties would join, this sign faced Smithtown Bypass. We're also requesting variances for an awning sign beneath this wall sign. This awning sign was installed in 2006 before the current awning sign regulations were adopted, which is why it requires the variances for its shape and for the writing on other than the flap. These signs replace signs that were existing for quite some time and provide needed visibility from Route 347 for the car wash. We're asking for similar variances for an awning sign facing Southern Boulevard. It was also installed in 2006 and therefore requires the variances that the awning sign on the south side of the building requires. It also needs a height variance of 3 inches. I realize that the advertisement says 12 feet to 13 feet, but it's actually 12 foot 3 that the top of the awning sign is. This is because the awning's located above the overhead door where the cars come out of the car wash. This sign, again, replaced an existing awning sign that was on the building for a long time and provides visibility to Southern Boulevard. Now, I understand that the signs that were existing prior to this weren't approved or permitted, but I just wanted to show that the signs had been there for quite some time. As far as the ground signs go, we're requesting a height variance for a ground sign at the rear of the lot, which serves as a menu for the services offered by the car wash. It seems like a significant request because you're going up from 32 square feet to, I believe it was 137 square feet. The sign, really, even though it's such a large sign, does have little impact on the adjacent properties because of its location on the site. It's set back on the site, it's behind the gas station building, and there's a fence on the other side of the property facing the funeral home, so it doesn't, you really don't see the sign until you're on the site. The sign serves as an important function for my client because what it does is it allows the customers to see what services are offered while they're in their cars in the queuing line, and it helps the line move more efficiently because people don't have to get out of their cars and wait till they get up there to determine what they're going to do. The size and the height of the sign are necessary because of the way it's situated. The cars drive underneath the sign, so that's why the height is, we need that increase from 15 to 19 feet. And there's the two lanes of cars that go underneath the sign, which is why the sign is so long in length. A final request for the ground sign is for a ground sign located on the gas station property on the corner of 347 and Southern Boulevard. The sign was existing when the two properties were combined. When they were split, the owner of the gas station came into an agreement with the owner of the car wash, who's since changed hands, and now the owner of the current car wash has an agreement with the gas station owner to maintain the sign on his site. This sign is extremely important to my client because it provides great visibility for cars traveling on 347. We feel the height increase is not that significant. It's going from 15 feet to 16'8". And the area request also seems a little large, going from 32 to 72 square feet. The actual face of the sign is only 36 square feet, but because the sign thickness is 18 inches, it's counted, the face of the sign is counted twice because of the zoning ordinance says any ground sign over 12 inches thick, both faces are counted twice, or counted the same. So due to that calculation, we're going from a sign that's really going from 32 to 36 square feet, it becomes 32 to 72 square feet. As far as the area variance considerations go, variance we feel would not produce an impact on adjacent properties in the neighborhood because the signs and the structures have existed for quite some time and it hasn't impacted the adjacent properties in the neighborhood as of yet. We feel the request is not substantial because even though there are a number of variances, the signage is typical of car washes. You see these menu signs on pretty much every car wash. Maybe not set up the way this one is, but they all have to have some form of showing people what what the services are. Excuse me. And due to the location of the site, all of the wall signs face a road frontage. Granted, the ones on the south side of the building are behind the gas station property, but they're open to Route 347. The benefit cannot be achieved by an alternative because, again, the signs facing Smithtown Bypass are critical to the success of the business, and the menu type sign is necessary for the patrons to see what services are provided. The variance would not cause an adverse effect on the environment because the signs and the structures, again, have existed for some time and there has not been an effect on the environment that we're aware of. The difficulty was created by the applicant or the former owner in this case because the signs were installed, the signs and the structures were installed without the benefit of permits. Therefore, we are here tonight seeking relief of these requirements. So if you have any questions, I'll be happy to answer. I'm sure you will.
Okay. I don't know how the other board members feel, but I really don't see the need to have signs saying car wash, car wash. I mean, it's really substantial as far as these signs are concerned.
Understood. And the one that you pointed to, the one that's on top, the wall sign above, that's actually the only one that is permitted right now. I know, like I said, in the past there were awning signs there from the previous owner. I guess they slipped by over the years. It happens, and these things replaced them. The old signs actually were. When I saw the photos of them, they were all very faded pink looking. They could have been red when they were first put up. I don't know, but these are much more attractive looking signs than what was there before. Believe it or not.
Okay. The other issue I have is that we visited the site yesterday and we walked through. You do have some things that are still. I know when you first came here, there were a lot of conditions, and then I know you didn't follow them because you didn't. There was.
Correct. Yeah. That was for an addition to be put on the building that was never done. So, I guess that application becomes null and void.
So as far as the other conditions, as far as the office trailer, the other trailer, you have carports out there, car parts out there.
Okay.
So
I'm sure we can get them to clean up all the car parts and everything. The office trailer that's there, my client actually is in the planning process of looking to do an addition to the building. Once he gets this all cleaned up, he's looking to do an addition to the building, and once that's done, then the office trailer that's near where the cars queue in, where they pull up, that would be removed. But at this point, he needs that space for the business end of the business. He need for I believe that's where like they do all their bookkeeping and things like that.
and what about the other trailer that's there?
The other trailer, I believe, if you talk about it, there's a storage trailer on the back of this, I guess it's what, the northwest corner of the site. I'd have to confer with my client, but if it's required that he removes it, then, yeah, if that's what it would take to help him get this approved, then I'm sure he would agree to that.
Okay, planning?
If I could mention just a few things. Overall, the sign variances requests are pretty substantial, and I think that in some ways they have quite an impact in two ways. One is businesses watch each other, and variances, I mean, let's just say you're in the filling station business. Variances granted for one filling station are noticed by the competitors. So I would imagine that the other car washes are keeping an eye on this. On the other hand, though, it is their business, I presume, requires exposure to Route 347 to be successful, because this is really on a side street. It's very close to the corner, but it's on a side street. So it is a little bit different.
Okay. Do we have to stop? You have about 2 minutes that we have to break.
I'll talk fast. But I think that there's some redundancy. You want me to stop now?
Yeah, why don't we just stop and, yeah. All right, let's just stop for a minute until we change the tapes, please.
Okay.
Thank you.